Hello, everyone, and welcome to a special episode on the Supreme Court Observer channel. I'm Advay Vora, and today we are joined by Gautam Bhatia, a practicing advocate from New Delhi. Many of you know Gautam for his blog, The Constitutional Law and Philosophy. You may also know him as a speculative author who just recently released his third novel, The Sentence, in 2024. Hi, Gautam. Thank you so much for joining
Hi,
us
hi.
for this conversation. So, in today's episode, we are going to discuss his latest book titled The Indian Constitution A Conversation with Power. Gautam has written about the Constitution as a document that creates, shapes, channels, and constrains power. He views this document and the many institutions that it gives birth to, including the judiciary, as a battleground for different visions of power contesting for supremacy. We're excited to have you here, Gautam, and to dive into your work. Well,
Thank you.
to begin today's discussion, can you tell us a bit about your book? What is it about and what motivated you to write it?
Yeah, I mean, so the book is it's about the Indian Constitution. It's obviously published in the 75th year since the Constitution came into force. And I think one of the reasons that motivated the writing of this book was perhaps a sense of disconnect with the major discourses around the Constitution, which took the form of, broadly a very rights focused approach to the Constitution, one that focuses extensively on the fundamental rights chapter and often the question of the nature of the Constitution, its transformative or progressive, or even critiques of its conservative character, really focuses on fundamental rights, what those rights do, and how they are sometimes insufficient, and so on. And often the critique of judgments, especially over the last 10 years or so, would take a specific form, which is that yeah, the Constitution is a wonderful document. It's basically it's fantastic, and often the problem is that the court interprets it wrongly, or interprets it in a regressive direction, or in a direction that is in a certain sense contrary to its transformative or otherwise progressive aims and purposes. And the different parts of the Constitution then often end up being discussed in silos. So if you look at federalism, you look at federalism just as a question of center-state relations and like a standalone element of Indian constitutionalism. Or if you look at separation of powers, the executive and the legislature, again, it's just, there's a few cases, you read those cases, you extract doctrine, and that's it. So these two things I found were, in a certain sense, presenting a somewhat incomplete view of the Indian Constitution, and I thought the unifying factor, one that would actually bring different parts of the Constitution into conversation with each other, is the unifying theme of power, which is the question of how along different axes, which could be the axis of rights, it could be the axis of center and state, and so on. The Constitution envisions the way power is created, distributed, constrained, and so on. And so the idea was to basically draw a power map of the Indian Constitution, which would cover it in its entirety, so not just one part or one chapter, and would then draw the links between different parts of it using this approach of power. And that's what the book does, chapter by chapter.
So, when you say so far the conversation about the Constitution is very rights focused, is this what you mean is that what you mean when you say constitutional common sense in the prologue?
No, no, constitutional common sense is a little different. So, constitutional common sense is a term that I use in this book. It's used, a similar term is used elsewhere, constitutional culture, or conventional constitutionalism. And the idea behind the constitutional common sense or constitutional culture is that there is, of course, the written constitution, there is the interpretation, and so on. But those who are internal to the legal practice, which means and includes practicing lawyers, judges, to an extent, legal scholars, and so on, those who are internal to the legal practice, over time develop a consensus, an unspoken consensus around the kinds of constitutional arguments which are legitimate and those which are not. And there is no you wouldn't find this written anywhere. It's not even articulated, but it's just something that it develops as a kind of common sense, which is
Yeah.
unspoken. To give you an example, and this is something that we also discussed in the book launch a couple of days ago, when I was doing the Article 370 case, there was a question with respect to the the normative significance of the Constitution of Jammu and Kashmir and its relationship with the Constitution of India. Because, of course, as you know, Jammu and Kashmir, in the history of the Indian Union, is the only state that had its own constitution. Now, if you look at federal structures across the world, there is nothing particularly extraordinary about this. Right? In the US, states have their own constitutions. In more than one federal polity, the idea that both units of the federation have their own constitutions is quite common,
Yeah.
and that there is no hierarchical relationship per se between these constitutions. They work in their respective domains
Yes.
for various reasons that we can go into later on. That argument was a non-starter in the Indian context. It was very clear that the only as a practitioner who was sort of arguing the case and sort of crafting the submissions before the court, it was very obvious that the only possible relationship that the court will accept is one of hierarchy, where the Indian constitution occupies a hierarchically superior place to the constitution of Jammu and Kashmir. Now, if you were an outsider looking in, you'd be like, why is that? There's nothing inherent to federalism or even the Indian constitution's text that requires that to happen. So explain why. But as an insider, all you can say is, look, this is the way it is. So what I argue in the book is that very often what we've seen across domains of constitutional practice and interpretation is that there is a constitutional common sense that centralization of power is what the constitution requires in different domains.
Yeah.
This is not uniform. There has been a pushback to it, of course. At certain times, this is stronger, certain times it's weaker. But over 75 years, when faced with interpretive disputes or interpretive, ambiguities and constitutional questions, there is a tendency on part of the court and on part of the people internal to the practice that ultimately uh, this is a centralizing constitution, even though it may not necessarily be textually there or there in that sense.
Yeah, that actually brings me to my next question. That one of the big arguments was that there's a centralizing drift in
Yeah.
federalism and asymmetric federalism.
Well, no,
But
across the board, not just these two,
yeah,
but yeah, yeah,
but you also mention a specific link between civil rights and federalism.
yeah,
So could you elaborate on that? Is the
yeah.
constitutional text kind of working against the very rights that it is seeking to protect?
Yeah, so I mean, if you look at the case of Kartar Singh, the one
Hmm.
that upheld the TADA, of course, it's known for its fundamental rights arguments and the court's, sort of acquiescence to extraordinary laws that limited fundamental rights. But the first challenge actually was a federalism challenge in Kartar Singh. The argument was that the union does not have the competence to legislate on this issue. And in many of the classic civil rights cases, you'll see that the opening argument is a federalism argument, and it's about competence. So the union does not have the competence to reach so far into what are basically states affairs. Challenges to the Central Bureau of Investigation, to the NIA Act, and so on are all federal challenges. So in that sense, the issue of rights is very closely bound up with the federal issue. Now, does this mean that um, devolving more power to the federal units will lead to better rights protection? It does not mean that, of course.
Yeah.
And to know that, look at the United States, red states, blue states. Often you will need, in fact, I mean, the whole argument for a federal law on abortion in the U.S. is that red states otherwise will criminalize abortion, right? So I'm not saying that. I'm not saying that devolving power to the states means that they will protect rights better. In fact, states often have their own versions of these laws that are rights violating. But in the Indian context, there does seem to be some kind of a not conceptual, but observational connection
Yeah.
between centralizing power and rights protection. And the
Hmm.
more you centralize power, the harder it becomes to protect rights effectively.
Well, that again brings me to the next question. Actually, specifically your chapter title writes, and I'm more
Mm.
focused on your observations about Article 21 and 22.
Yeah,
You say that Article 21 protects individual liberty in a thin sense. That is, the executive may, by the passing of a law, deprive citizens of their personal liberty if
mm.
the law upholds
Yeah,
due procedure. You say the same for Article 22, that it sanctions the deprivation of liberty by allowing
yeah,
Parliament to make laws for preventive detention.
yeah, yeah.
What would you say about the recent judgment in Radhika Agarwal versus Union, where the court
Mm.
upheld arrest under the Custom and the GST Act? And these are also
Yeah,
special laws. You use the examples of UAPA and the PMLA,
yeah,
but
yeah,
Custom and the
yeah.
GST Act under procedural fairness. And these judgments are being praised for endorsing fairness in arrest. So, do you believe there's something more to consider over there?
Yeah, so I mean, Abhinav Sekri has written a fantastic blog post on
Yeah.
this that I've republished on my blog as well, and I owe a lot of my understanding of these issues to him. Now, the problem with a case like Radhika Agarwal is that it basically, and this goes back to the 1960s, which is something I discuss in the book. Of course, the book was written before this judgment came out, but in that sense, it continues on that path. What happens is that the Code of Criminal Procedure and the Indian Constitution have a set of procedural safeguards for the rights of the accused. The idea being that you mitigate the power imbalance between, again, power is here, right? So between the accused and the state officers. And what then happens is that after independence, there's a range of special laws that are primarily designed to deal with socioeconomic offenses. Food hoarding of essential items, smuggling, and so on. So it's the Customs Act, all that, right? So this goes back to the 50s and 60s, and what happens is that in those laws, the Parliament designates officers who will carry out functions under those acts, and they are not formally police officers as defined under the CRPC,
Yeah.
right? So they're not the police for the purposes of criminal law or criminal legislation,
Yeah.
but they have the full panoply of coercive powers that the state, gives them to engage in law enforcement. And so the question then arises in these early cases, for example, is that um, if I, want to exercise my right against self-incrimination under Article 20, Clause 3, obviously it is established that I must be an accused, right? And then I have the right. But the question is that if I am being interrogated under a special law where the person interrogating me is not, a police officer, and it is unclear if it will lead to an FIR or not. That's also ambiguous. Then the court basically adopts a very formalistic approach and says, okay, look, these are not formally police officers. It is not formally a process under the CRPC. Therefore, uh, 20 clause 3 does not apply. Right? So
Yeah.
effectively, as a matter of definitional fiat, the court exempts this whole range of laws from complying with the constitutional procedural, safeguards of, you know, self-incrimination, arrest, all of that. Um, and that's been the consistent position last 50, 60 years. And this Radhika Agarwal's case is basically, a continuation of that.
Yeah.
Now, I think that, when people praise it, I think it's basically, when your expectations are in the basement, right? Even something small, you think is great. And so when the court says, yeah, okay, for arrest, like provide grounds and so on, this is all like, the big issue you decide in favor of the state, right? And that you basically saying that these guys are not police officers, therefore they're not bound by,
Hmm.
the constitutional obligations that apply to police officers. Core constitutional rights are not available to people who are under these laws. And then you say, okay, but we'll provide these little giveaways to ensure that there is some kind of little bit of, thing happening that would constrain some sort of conduct. But we need to remember that actually the court starting point is that the state, is being given all these wide powers with no checks, and then it's carving out these little exceptions for some small checks. So I think so I don't think it deserves any praise. Because, like I said, your starting point is extreme deference to the state, which leaves individuals pretty much at the mercy of the state. And then you add a few, salves, so to say, to make it more palatable. The thing to remember is that there are two ways to understand the history of the intersection between criminal law, procedure, and constitutionalism in India. One approach is for the court to say, okay, look, when the Indian Constitution provides this Articles 20, 20, 21, 22, what is it trying to do, right? So, who is it trying to protect? And as the court, our job is to ensure that those walls that the Constitution erects around, individuals to keep them safe from state incursion are maintained. So let's interpret the Constitution with that philosophy, which is basically first interpreting Articles 20, 21, 22 in like a pro-liberty direction, and then testing laws on the anvil of that interpretation. That would have been one way to go from the beginning. Instead, what the court did from the beginning is to say, oh, like there are all these like colonial like laws which provided some safeguards, some basic safeguards, and I mean the goal, of course, is to effectively arrive at the truth and help investigating officers and so on to do their job. We will read down the constitutional safeguards. Uh, so that they are equivalent to the old colonial CRPC, right? So what the court does in these early cases is that effectively it so that the rights that were there before the constitution are still all that you have, because that's what the constitution now is supposed in the court's mind. That's what it does, and that's been the position throughout in history. And Radhika Agarwal's case is an example of that philosophy continuing, right? So
Yeah.
basically, you try to minimize the scope of the constitutional guarantees by basically narrowing both the group of people who can avail of those rights. So, like I said, if you're arrested under one of these laws, special laws, you don't get those rights, and by diluting their force.
So, what about the conversation that's going on right now ever since the favorable bail orders for Arvind Kejriwal and Manish
Yeah,
Sisodia? And they are saying that the court has started to, whittle down the PMLA and making it more pro-liberty, and the
yeah,
bails are becoming more pro-liberty because of long periods of incarceration and etc.
yeah,
Would you
yeah.
suggest that these are one of those where the court just gives a little bit of a win once in a
No,
while?
no, not at all,
No.
because I think again
Yeah.
it depends on what your baseline is, right? So
Yeah.
the people, I mean, these people remain in jail for a long time, right? Like
Hmm.
a year, year and a half in these cases, right? I'm not even
Yeah.
talking about your UAPA bails, right? Those
Hmm.
are, I mean, those are you're talking about 4 or 5 years over there, at
Yes.
least without trial, right?
Yeah.
And so here are people who stay in jail, right, for long periods. I think Sodia was a year and a half, perhaps. So it was a very
Yes.
long time, right?
Yeah. Very
Now,
long.
there is no, that is not acceptable, right? Like to start with, and to then say, okay, like after 1.5 year bail is given, and that's like a win because the court is becoming pro-liberty. I mean, I think it reflects how, as a legal culture, we have accepted and normalized that, yeah, okay, year and a half in jail is fine. Like that's okay. It's only after that that we start worrying. But it's okay. Like if you're arrested, then you might as well resign yourself, being in jail without trial for like, at least a year. Like that's okay. Then we'll see what happens. I think, and that is actually, if you think about it, that is a terrible thing to normalize, right? Like jail is not a joke, right? So being in jail is serious. But we seem to have really, diluted this idea that it is acceptable to imprison someone without trial, and you only do it in like exceptional cases where literally there is no other choice, and you try as soon as possible to ensure that either trial happens or you release the person on bail pending trial. So that philosophy is gone, right? And again, I mean, again in the Kejriwal case. Uh, like I said with the Radhika Agarwal case, the actual doctrinally, it's a very, very minimal, thing the court is giving. And even there, I think they still have to, they refer to question of what does that, reason to believe actually mean, like extent to which the court can review it, right? It's still giving a lot of power to the state to really imprison people at will.
Yeah.
And one thing I think I want to point out is that I think one thing the court keeps doing is that uh, through these all these bail orders, right? Like which basically are very discretionary, right? Um, Instead of actually, and I've written about this. I've called this sort of basically the court creates a culture of patronage, right? Where instead of reading down the legal provisions or striking them down in a way that the state cannot have that power, right? And or sort of rebalancing the individual state power equation, the court upholds those provisions, right? And they're there. And then it takes upon itself that task, okay, we will decide if in a particular case it's a meritorious case for bail or not. And ultimately it becomes the court starts to use liberty as a kind of patronage thing, right? Okay, we'll give
Yeah.
you, we won't give you, like you will get it after 2 years, you after 4 years. That's not, again, like that. The book's theme is power, right? And this is
Mhm.
like basically giving a kind of unaccountable power to both the executive and the courts in terms of individual liberty, um, instead of like curtailing that discretionary power, both to like incarcerate and to arrest and all of that on the one hand, and then to decide when like bail can be given or not on the other. So I think that that remains a problem.
Moving to the next question. Your book becomes a part of a series of new scholarly reviews of the Constitution.
Mm.
Your peers also critique the Constitution, where some describe it as colonial or
Yeah,
communal,
yeah,
and some suggest overhauling the text
yeah,
entirely. While you also say that the current design of the Constitution enables a centralizing drift,
yeah,
but you carefully suggest that the Constitution requires an alternate reading.
yeah.
Are you then in favor of retaining most of the provisions that are in the text, or what does this alternate reading entail? Is what
No,
I want
I
to
mean,
ask.
so I think, so I don't take a position either way. I mean, so I
Yeah.
see the task of this book as being diagnostic, right?
Hmm.
Which is to say that it's an attempt at diagnosing problems. And as I said, the reason for that was that I found that there was, um, I was unconvinced by the argument that the issue is judicial interpretation that is wrong or misplaced of like a fantastic constitution. So I thought we need to have a conversation about various design issues in the constitution, and how the constitution by design and structure, of course constitutions are open-ended documents, right? So interpretation is always possible, but the text and design can facilitate certain kinds of readings and make others harder. And I
Yeah.
take the example of Article 3 states, all that as an instance of that, right? And so the argument of the book is that this is a constitution that, by its design, facilitates centralizing reading, which is the drift, and the courts have accelerated that over the years. Um,
Those
and
inflection
also
points. Yeah.
inflection point judgments, yeah.
Yeah.
Also that there is a reason, there are reasons why when the framers were designing the constitution they wanted to have that drift.
Hmm.
Now the argument may be that okay, that no longer holds those, so that's a different argument. But I think it's also important to just to understand that it's not that the centralizing drift is accidental, right? Like it actually, there were reasons why it was very intentionally embedded in the constitution. Right? Now, what do you do now about that? That is not the task of this book, because some people will believe and sincerely hold the view that actually centralization is good. So we are like a fractious, country. We need like that centralizing, power to hold us together, and that's an argument. So if that's your belief, then this is a great constitution, right? Since it
Yeah.
actually achieves that, in a very good, in a very subtle and but unmistakable way. If you believe that actually, this is harmful, then the next question you will ask is that okay, can I interpret it in a way that would then move it from that, position? So I think like this is, where you want to go from the diagnosis is depends on where you stand and what your views are.
Yeah.
Um, I think the two things I'll say though. So I think one is, like I said, constitutions are not rigid or static documents, right? Constitutions are terrains of contestation, which I say in the book. So there's always contest over what a constitution means. And so again, what you want to do depends upon how you engage with that process. The second is that, of course, this book is about the constitution as a legal document,
Yes.
and a political document, of course, and the way that the contestation has played out in court, because that's my area of competence. I am a constitutional lawyer, and a writer, and so that's what I understand. But of course, the constitution goes much beyond the courtroom, right? In fact, it arguably plays its most important part outside the courtroom, in popular imagination, in just in the way it becomes part of the discourse. And of course, the interesting thing is that of late, perhaps much more so than usual, the Constitution has entered public imagination over the last few years, right? Perhaps much more so than it used to be earlier. And so it also there's a difference between the Constitution as an artifact of public imagination, right? And the Constitution, which is argued about in courts and which becomes the enforceable law, so to say. And in that way, again, if the question is what you have to do with respect to centralizing drift, the answer is not just in court, but also, of course, outside of court. Because if popular imagination imagines the constitution a certain way, ultimately institutions respond to that, right? So I think it's a much more complex argument than okay. So once your diagnostic task is done, which is the book's task, then okay, either you change the constitution or you interpret it, or if you support that reading, then it's great. No changes needed, right? It's much
Yeah.
more, I think, layered than that. But I think the what I want to do with the book is to initiate that conversation, about the centralizing drift, which is, so of course also the centralizing drift is not a new, it's not a new argument I'm making. Many people have argued that, yeah, in the federal structure, it's skewed, this is bad. Right now, your whole thing of the languages, all that, right? So in different constitutional domains, there's long been the understanding that in the federal scheme there is centralization, all of that. That's not so it's not new. I think the contribution I'm making is that I'm weaving them all together, right? In one sort of overall uh, holistic kind of analysis of the constitutional design. And I think that's the contribution, and that should hopefully spark a conversation around what role does this design have to play in modern India now, 75 years after independence.
A much unknown fact to a lot of people is that there were many versions of draft constitutions which you have examined also,
Yeah.
like for instance of M.N. Roy,
Yeah.
Shivan Narayan Agarwal, the Socialist Party
Yeah.
of India.
Yeah.
Would you say that some of these draft constitutions confirm with the alternate reading that you're proposing?
Yeah, I mean, so for example, there is one chapter I have on the people, right? So
Yeah.
the preamble of the Constitution says we the people, and then there is no further appearance the people make after that, right? So they just disappear in a certain way. This is not something that is, at all necessary, because many constitutions, and especially more recent constitutions, uh, understand that pure representation through parliament is not enough in terms of, you know, keeping people involved and, you know, creating that space for popular involvement in governance. And so they have multiple avenues. So it's in some constitutions, certain amendments require a referendum, a downstream referendum, right? So that's one example. Right to recall legislators, all of that. So there are many things that can happen. And I think the interesting thing is that these ideas you see a lot in these draft constitutional documents that were put forward around the same time as independence. So M.N. Roy's
Yes.
draft constitution, the Socialist Party's draft constitution, the Gandhian constitution, very, very interesting document, in fact, and extremely, I think that's the most, for me,
Yeah.
it's the most interesting of these documents. And of course, the Hindu Mahasabha's constitution, also very interesting document. And so what you see these alternative visions that are there that I think overlap more with the decentralizing vision of the constitution that I find more attractive than the
Yes.
centralizing one. Yeah, yeah,
My next question is a bit more about the craft than the
yeah.
subject matter. At the Supreme Court Observer, much of our work revolves around simplifying legal jargon and
Right.
complexity for the average reader.
Yeah.
You're a prolific writer yourself. You've written on your blog for over a decade,
Mm.
and you also have editorials, books, novels, and newsletters too.
Yeah.
Could you tell us a little bit about your writing process? As an advocate in the day, how do you often find the connection between language and storytelling? You can also talk about the science fiction books that you're working on.
Yeah. So I think like the writing process for nonfiction and fiction is very different.
Yeah.
So for nonfiction, um, yeah, I mean, so legal drafting is of course one thing where you try and be as precise as possible, as direct and as brief, and make the argument as austere as you can. Legal academic writing is a little different. Of course, the principles are the same, but it's a little different in that you can be more adventurous. You can push the envelope a little bit more. You also, so good legal scholarship, like any good academic writing, must follow the principle of charity. That's what it's called, which means that you have to actually take your intellectual opponent's arguments and give them their best version, and then engage with that best version of the argument, right? So if I don't agree with the centralizing drift, I must nonetheless explain why that
Yeah.
is there. So what was Ambedkar's thinking? Ambedkar's thinking was that he had a history of experiencing just how local and entrenched power structures effectively were severe impediments to the exercise of people's rights and specifically Dalits' rights, right? And so he thought, he believed that the only way that you could overcome those entrenched hierarchies at the local level was by having a strong central power who would be able to actually overcome those local structures. And so for him, it was important the constitution have that strong central power. For Nehru, who had a vision of the developmentalist state, the only way you can actually have development that would lift India out of the kind of poverty and illiteracy that was there is through an executive focused constitution. So basically you have to sort of give those arguments their strongest form and then ask yourself, okay, are they still
Yeah.
convincing? So I think that's the big difference in terms of legal academic writing and legal drafting. In legal drafting, you don't
Yeah.
even admit the other person as an argument, right? Like you have to basically, I mean, the whole thing is that this is the only possible answer is this, and my opponent is like completely misguided, right? And that degrees of rudeness with which you like say that or make that point in your draft, depending on your, I think, personality, right? So like you always say, for reasons best known to themselves, they have argued this, so stuff like that, right? So that's the difference. In terms of fiction, it's totally different, right? So if for fiction in general and for speculative fiction, which is what I write specifically, although there is an intersection of law and SF in my more recent writing, is that the whole purpose is indirectness, right? So you communicate the story um, through indirect ways, right? Like you're not supposed to make a point, right? You're supposed to actually approach issues indirectly, glancingly, and through that you illumine, certain ideas, certain themes. So you're using language in a very different way. Much your
Yeah.
use of language is much more ambivalent, much more ambiguous, much more open-ended. And of course, the other big difference is dialogue, because any good novel will have dialogue, and there is a massive difference between the written word and dialogue. And so one
Yeah.
big thing to unlearn, and almost daily unlearn, because if I'm doing the two kinds of writings on a daily basis, is to unlearn the written word and to get back into dialogue writing when I'm writing fiction. What am I working on right now? Yeah, so The Sentence, which was the latest novel that came out
Yes.
in November. So that's sort of, it's been around 4 months. And I'm presently working on sort of kind of like a sequel to it, which is set around 12 years in the future. I think the interesting thing is actually that in The Sentence, I think interesting for your listeners, is that there is a very strong connection of the two worlds, law
Yeah.
and speculative fiction, in the sense that The Sentence is a novel about death penalty in a certain way, um, and what would happen if you actually could reverse death penalty, right? And so in that sense, it involves a legal case. It involves legal arguments. It involves the process of crafting legal arguments to make or to do or to win a legal case that would, in this case, get a person revived from death penalty. Yeah, so in that way you actually see elements of both kinds of writing, because of course if you're showing someone working on legal argument, then that life comes in, right? So it's a blend of the speculative fiction, the fiction, and the law
Yeah.
that comes into that work.
Well, that brings me to the next question, which I'm perhaps asking for myself. Maybe you can call it maybe as a personal advice. How do you manage to juggle so many interests? You work, you have the law, you work as an advocate, you write on your blog, you also keep up with football, and you also tweet, you travel, and
Yeah,
of course your science fiction interests.
yeah.
How do you manage to find time for everything, specifically when you're working on a book such as this one or
Hmm.
the sequel to the sentence?
Yeah.
Do you have something like a minimum number of words that you
Yeah.
aim to write every day or
Yeah.
something?
Yeah, so I think like I think there are three answers to that. One is a very practical answer, which is that yeah, I very consciously keep my legal practice down to a certain level that would allow me time to do other things.
Yeah,
Now, if you no one is superhuman, so if you have a legal practice that sees you in court at 10 a.m. Or if you're in trial court 9:30, um, and then you're in court till 4 p.m., which you say you have like your 5 or 6 matters a day, which is say the practice of uh, a good lawyer in the mid 30s, right, would have
yeah,
say 5 6 matters a day. I am being in court till 4, and then your briefings begin at 6, right?
yeah,
Now add to that family obligations and stuff. There is no way you can do other things. Of course, you can have interests, hobbies, and all that,
yeah,
which people do, and that's great. And I know many of my friends do. But you can't do another thing as another thing, a full thing, which is equal to this, right? It's this.
yeah,
This has primacy, this has priority, and everything else will have to be woven around that, right? Now, I always knew that that's not something I want to do. So I consciously chose to in that sense be less ambitious about legal practice, and so I end up in court perhaps twice or thrice a week. And in those days I'd have like one matter, maybe two sometimes. And that's, yeah, and I frequently say no to work. I tell people, and this is, I tell them that, look, if you want a draft, or if you want, like, if you want to give me a draft to do, you will need to give me a week's lead time, because I will then have to organize other things around that, right?
yeah,
So don't do this thing where 8 p.m. you send me a draft and say we want to draft by like midnight, right? I'm not gonna, if I am in the middle of writing my novel that evening, I'm not going to like stop and kick it to
yeah,
the one side and do this, right? So give me enough time to organize that and integrate that into me,
yeah, yeah.
which of course means that my practice is not what it is of,
Hmm.
of, of people my age, um, which for me is fine, right? But for many people that wouldn't be, and that's completely understandable. So I think the first very practical answer is, if you want to do multiple things like in a full-time way, then you have to drop how much you want to do them, and that would mean lowering your ambitions, right, in tangible ways. That's one thing. Secondly, yeah, so in terms of number of words, so this is something that depends completely on your method. So there are writers of fiction who have that word count, right? So every day 2,000 words have to be written, and for them, and they swear by consistency, right? I'm not that writer. For me, it's always, there'll be like a dry spell of like a couple of months, and then suddenly the words will come, and then for 2 weeks I'll write nonstop, and then it'll be like a draft, right? So, and then again there'll be a block which is just the way it works for me, and I've accepted that. Of course, once the first draft is ready, then you have to edit it consistently.
Yeah.
Then you can't do this chaos thing. The chaos works for your first draft. It doesn't work for post first draft, when you have to sit and actually edit the whole thing. Which again for me, therefore, if I was to have that sort of practice where where every day is work of a certain degree, I couldn't do this, right? Then you can't suddenly say, okay, this week I will just write my fiction. You can't do that if you have like a certain kind of practice in terms of volume. So that's point two. Uh, and point three is that for non-fiction, my legal writing professor, when I was doing my master's, said this one thing that I've always kept in mind, which is writing is like a muscle, right? So the more you exercise the muscle, the easier it becomes. The
Yeah.
less you do it, the harder it becomes, and then you strain, you sprain, all of that, right? So in non-fiction, I think writing regularly is just, there's no other way around it. Because the more you write regularly, the easier it becomes, the faster you become, and then you can just do clean first drafts, right? And that really saves a ton of time. And I think, like, if you look at, so the blog I write, if you look at the number of posts and then divide that by the years, the blog now it's 12th year, you will find that on an average it's 2 posts a week for 12 years. right?
Yes.
And yeah, I mean, and that's why it becomes easy, right? Because then the more you do it, it's almost second nature. And then now as a judgment, you just know, like, you don't need to spend time organizing your thoughts, organizing your piece structure. It just is intuitive after a point, right? like
Yeah.
like anything you do, you know I think there was this thing, right? Like there's this from some martial arts movie, I think some Bruce Lee movie. There's a thing that I don't fear the man who knows like 1,000 kicks, but the man who does one kick 1,000 times, right? So it's basically, yeah, you do the one thing 1,000 times, and at the end of it, it's intuitive, so it
Yeah.
just very quickly and naturally. So I think that's it does take time, but if you're consistent with legal writing, then at some point it will become very quick and very easy.
Well, that concludes our interview. Thank you so much for giving us this time, Gautam. It was an
Thank
absolute
you.
pleasure. It was an absolute pleasure speaking with you regarding this book. I'm looking forward to hearing more about what people say about the diagnostic that you
Yeah,
given in this
yeah. I mean,
book.
I think I
Yeah,
don't know if you saw. I don't know if you saw the book launch video, which is online.
yeah.
But so one thing that I want to do in book launches is, and I've done this for all of my launches, is I think it's boring if everybody comes and says, "Oh, what a wonderful book! What a
Yeah.
wonderful guy! This is amazing. We love it." So I got people I knew who would not instinctively agree with many of the things in the book. And so we had like a fantastic discussion because they
Yeah.
pushed back, right? So yeah, so I'm looking forward to have more of that, than, people saying,
Yes.
oh, like fantastic book, amazing, like 10 on 10, no notes, and that doesn't help anyone. So,
Mm.
so I hope there will be pushback and there'll be, like a
Yes.
generative disagreement over the book's claims.
Well, I'm looking forward to more commentaries on this and hopefully more book reviews soon on journals and etc. Yeah.
Yeah. Yeah.
Well, thank you.
Yeah. Thank you. Thank you so much. See you soon. Yeah.
See you.